So I'll start with a really general question. Just talk about some traps at trial, things to avoid that either preserve your trial rights, but more importantly, perhaps at the end of the day, your appellate rights.
I think judges think that in a way they're a lawyer that got promoted. They're sort of the bus driver for all of the lawyers on the bus, and are there to stand for the profession and the integrity of the profession. So one of the things I try to balance is when a judge interrupts me, which happens all the time, is to get the sense that, first of all, the juries usually like the judges, so I can't confront them directly, but also to recognize that there's an attempt to thwart. So I've got to balance both protecting my appellate rights and persuading the jury with also making sure that the judge isn't going to take over my case at the same time.
So I'm just curious, how do you approach your key exhibits when you're going to trial?
Well, as you were asking that question, I was thinking more about experts. What I try to do in preparation for the cross-examination of an expert is to find every single thing that the expert has written and read it. Everything, without exception. Try to find it. With the internet, it's much easier, but whatever it takes to get it, that's what you have to do. Find every single bit of evidence, because that's what juries are expecting. Juries' expectations, I think, are set by TV shows, by the way the culture is right now, very confrontational, and they're expecting a knockout blow if you can deliver it. And so, if you have the chance to, you have to prepare in a way that allows you the chance to do that. Same thing on openings. I think they're expecting a story, and they're entitled to it. A story that actually holds together. They're expecting a story that's consistent with, as some of the lawyers are trying to do, with how they're viewing the world already, that domestic violence is a big problem, or that people do things for money that are really shameful. And they want to know that they can count on you, that what you've told them is true, and you're going to be able to prove it at the end. So you really, I read that, I think it was Motley, the great lawyer from South Carolina, that was what he did. That was what actually got me thinking it's not enough to prepare well. It's what you have to do is read everything. Sure. I mean, I think the experts are partisans, and anybody who's tried their first case with an expert knows that an expert is not really there to try to explain the law or how this fits into law. The expert is there, in my cases, which are legal malpractice cases, to argue for their side. They wouldn't be hired, and I think every lawyer knows that, and everyone in the insurance business knows that as well. That it's a further lawyering of the case. So you have a pretty good idea that you're not going to get concessions easily. So you have to be, you have to focus on the very things that a jury might understand from the expert testimony. That's particularly important with an engineer or a doctor, something in a technical area, and make sure that you can actually hit them and show that there's something wrong in what they've done in an area that, like that, that a jury is going to be able to understand. And you get enough information from the expert and about the expert through the internet, through the expert report that you get, through prior trial testimony and deposition testimony, to get a pretty good sense of where they're going to go. And then you have to get up, make those points, sometimes by asking open-ended questions. Just as an aside, my personal trial style is to do that more, to have open-ended questions and to do the thing that they tell you in law school you shouldn't do, which is ask the why question. If you think you know the answer, if you're willing to take the answer and then follow the thread of what the answer is. There's a lot of lawyers typically, and a lot of the best lawyers sometimes will, ask yes and no questions and try to train the witness into answering a certain way. My own style is not that way, and I think, in my opinion, and for my style, juries are expecting more of what looks like a conversation. From my point of view, it is, and I've got a job to do. I'm trying to knock somebody's head off or discredit them, but I'm asking open questions in the doing of that and not trying to get them to just sort of, in these tiny little steps, baby steps, admit that something they have is a little bit off. I'm really trying to get to the substance of what they're doing or what parts I can get to and then stop it.